So you have your green card or your citizenship, but you want to file for your child. However, you forgot to include them in your green card or citizenship application. Now you're wondering if it's possible to even file for them and if it's going to affect your own status. Well, in this video, I'm going to tell you about how it could affect you, how it could affect your child, and what you can do to overcome it. I am U.S. immigration attorney Lilian, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. I get so many people that come to me after they already made the mistake of not including their child in their green card application, in their visa application, in their citizenship application. And now they have their green card or they have their citizenship and they want to file for that child. And they're wondering, how can I even do this? Is this even possible? Well, I'm going to be going over the different ways that this comes up and what you may be able to do. In some situations, there is no option. I will be honest with you about that. Okay. In certain situations, you may not have an option. However, I'm going to give you a breakdown of the different situations and the options that may be available to you. So let's start with a father that files, let's say, a visa application, a green card application, and never included their child in there. And they had a child before they filed those applications. Let's start with the case of a father not including their child in their application. So when a father does not include their child in the application and they come to me and they want to file for their child, my first question is always, did you know you had a child? Was there something about the relationship with the mother that led you to believe that this child may not be yours? And that's the reason you didn't include the child in the application. If that's the case, then guess what? We can still now put in information about the child. You will need to most likely get a DNA test to prove that the child is yours. USCIS may question why this child all of a sudden came up, and you may need to include affidavits about affidavits from the mother and family members that knew about the child to basically state what you're telling USCIS is accurate, that you didn't know that the child existed or that you didn't believe the child was yours. You never legitimized the child, so therefore you couldn't include the child in your application. So it is really important that you are able to document when you found out about the child, when you found out that the child is actually yours, in order for it to be a defense in this case. In a marriage based green card application process, you are asked about children. And the reason USCIS asks you about children is to see if there are children that were born during the marriage, to see if there's questions to be asked about the ex wife or ex girlfriend that led to the child. They want to know those information so they can ask you all those questions. By not including the child, USCIS may see that as material misrepresentation. However, like I said, if you can prove that you did not know about the child or that you did not know the child was actually yours, then it would not be considered material misrepresentation. In those situations, you can still file a green card application for your child, but USCIS will most likely require you to do a DNA test to prove that the child is in fact yours. When the case is reversed and it's the mother that did not include the child in their application, this is going to get a little bit more complex because there is no, I didn't know about this child defense. Okay. If you are the mother, USCIS assumes that you know that you gave birth to a child and that the child will be included in your application. Because you didn't include the child, USCIS is going to question whether the child is actually yours or whether you just lied to USCIS. In either of these situations, it's a problem, right? If the child is not yours and you're claiming it's yours, That's lying to US immigration. If the child is yours and you never disclosed it to USCIS, that is also a problem. So, how can this affect the mother that is either a green card holder or a citizen? If the mother is still a green card holder, understand that depending on how the mother got their green card, this can be seen as misrepresentation, leading to USCIS questioning whether the mother should have gotten the green card in the first place. So, not only do you not include in your child jeopardize your child's ability to get a green card, it can also jeopardize your ability to keep your green card. When does this actually affect your ability to keep your green card? Well, if you got your green card through marriage and the child was born during that marriage, that raises questions of whether that marriage was real, right? Whether you entered into that marriage in good faith. But if the child was born, let's say 10 years before you got married or a year before you got married, then USCIS may not see that as material, because even if they knew about the child existence does not affect the marriage. It does not call into question whether that marriage is real. However, let's say you just got married and you had a child a year after marriage, and that child did not belong to your husband, right? Or that child did not belong to your wife, then USCIS is going to question the validity of the marriage, right? Was this marriage real if you're having children outside of the marriage? And also, not disclosing it to USCIS is going to raise even more questions of whether the marriage was real, whether you were trying to hide the fact that you had this child from USCIS. I have had this happen where the question came up at the citizenship stage, where the father already applied for a green card, got their 2-year green card, got their 10-year green card. Now they're applying for citizenship and they're including the child on their citizenship application. However, the child was not included in their I-751 application. Now, again, like I said before, a defense to this for a father is if they did not know that the child was theirs, right? There could be child that, okay, you had an extramarital affair and you may have gotten someone pregnant, but until you know for sure that that is your child, you do have a defense as to why you're not including the child on your applications. Because remember, whatever you put in your application must be true. So if you're putting a child on your application and you're not even sure if the child is yours, that could also be a problem. So for a father where they didn't put the child on their green card application, they didn't put the child on their removal of conditions application, and now at the citizenship stage, they're putting the child on there because now they've done a DNA test. They know the child is theirs, and now they can put them on the application. So that is a defense for the father, like I said earlier. Now, USCIS will always try to make the argument that it is material, especially, like I said, if the child was born during the marriage. So you want to make sure that you are including the child, you are disclosing this information so that you do not end up putting your own green card in jeopardy. So, just to recap real quick. So, like I said, father has the option to say, I didn't know the child existed, and provide documentation that they didn't know the child existed. Mother does not have that same option, right? Mother has to now show that not disclosing the child was not material to the case, right? It would not have made the officer make a different decision in the case. So you go to your visa interview for a marriage-based visa application. You do not disclose that you have a child. Your child is 10 years old. You got married to your husband 5 years ago. And you go to your interview. Now the officer finds out that you have a child and you didn't disclose it. And now they're questioning, if you lied to them or not, if they can still approve your visa or not. Now the question there becomes, is not disclosing the child that was born 5 years before your marriage material to you being able to get that visa application, right? Will they make a difference if the officer knew or not. So that's where the mother's defense will come in, right? If it would not have made a difference in the decision making, in the questions the officer asks, then it would not affect the mother's ability to file for the child or to now include the child on their green card application or their citizenship application. All right. So, father's defense, I did not know I had this child. Now I know, and now I'm including them in my applications. Mother's defense, I knew I had this child, but even though even though I didn't include them in my application, it wouldn't have mattered anyway. Okay? And father can use the same defense as mother, right? If the father knew they had the child, but it wasn't material to the case, they can use that as well. So the father gets two defenses while mother gets one. Okay? So it is really important that as you're filling out your visa application, as you're filling out your green card application, as you're filling out your citizenship application, that you are being honest and disclosing those important information, because guess what? Every single one of those forms asks you if you have children. And they do mean, do you have children anywhere in the world, not just in the US, not just, living with you, not in your, custody. They mean children anywhere in the world. By the way, if you are getting value out of this video, do not forget to hit the like button. Now, let's talk about what the child can do, right? If a child is in a position where the father did not include them in their visa application, the mother did not include them in any applications, they're in the US and they're trying to get a green card through the parents. Well, this is a bonus tip that may work in certain situations. Not everyone's situation is going to be like this, okay? Not everyone is going to qualify for this. So it's really important that you look at your particular situation and see if this would work. Bonus tip. For a child that wants to get a green card, however, their parent never included them on any visa applications, they got to the US on their own, and now they want to apply for a green card, but the parent is not willing to file for them, or the parent is abusive. Well, Vawa may be an option for the child. So Vawa is available to children that have been abused by their parents, okay? Children that have suffered physical, emotional, all sorts of abuse from their parents can apply for VAWA. Age does matter, okay? So your age at the time the abuse occurred and your age at the time that you filed does matter. However, a child may still be able to get a green card through VAWA, even though the parent did not include them on their application, as long as they can still show that that is their parent, showing that they live together, that they were brought up as a child, as their child. Typically, parents that don't want to disclose on applications about their children will still do school applications for the child, naming themselves as parents, medical records naming them as parents. So they are showing other ways that they're telling the world that this is my child, and the child can use that to prove the relationship between them and the parents. Okay, sometimes they have birth certificates with the parents' names on it. However, the parent never actually put the child on the visa application or on the citizenship and green card application. That is not going to affect the child's ability to apply for VAWA because they can still prove that relationship. Now, if you're in this situation where either your green card is in jeopardy because USCIS is claiming that you didn't put your child and it's material to you being able to keep your green card, or you want to file for your child and you do not want to take the risk of putting your own status in jeopardy, or you are in a situation where the child is not material, you want to go ahead and file, and you want to give yourself the best option of actually having the application go through without it affecting your status, well, go ahead and schedule a strategy session with me so that we can discuss your options, see what evidence we need to put together to best support your case and get you closer to your immigration goals. You can schedule a strategy session with me by going to my website, lilylegal.com, or by calling my office at 508-443-1788.